Hi, I'm Mike with Cashion Legal, and in this video, I want to cover 5 things that you should know if you're an employee and you're subject to a non-solicitation clause. Non-solicitation clause is a clause in an employment contract that attempts to prohibit you from engaging in certain types of activity during and after the end of your employment. If you're in a sales role, or if you're in a role that involves dealing with clients regularly, or if you're in a senior level position within your organization, there is a possibility that you have a non-solicitation clause in your employment contract. If you do have one of these clauses in your contract, I'm going to share 5 things with you that you should probably know if you're wondering how it might impact your next career move. Point number 1 is this: you can still compete even if you're subject to a non-solicitation clause. Even though you have a clause in your contract saying that you cannot contact specific clients, or there's certain things you cannot do after you end your employment, you are still permitted to compete with your current or former employer. So if you're subject to a non-solicitation clause and you don't have a non-compete provision in your employment contract, and you've been approached by a competitor of your current employer, you can consider this opportunity. That's because under the terms of the non-solicitation clause, there are just certain things you cannot do, like contacting certain clients or seeking out certain types of business. But this doesn't mean you cannot generally compete with your current or former employer. Tip number 2 is that there are certain things you can do to promote your new business or your new employer, even though you are subject to a non-solicitation clause. For example, one thing that you can do, even if you're subject to a non-solicit, is general advertising. So if you go on social media like LinkedIn or Instagram and announce your new role, or if you pay for an ad to announce the founding of your new business, this would not generally count as solicitation. Another example of conduct that does not count as solicitation is where the client contacts you first. If after you've left your employer, one of your former clients comes to you, you did not solicit that business because it was the client who sought you out. Similarly, if you have incidental or social contact with a client that was not designed for the purpose of soliciting business activity, this also may not constitute solicitation under the non-solicitation clause. The third thing you should know that if you're subject to a non-solicit clause is that it is more likely to be enforceable than a non-compete clause. If an employer is attempting to restrict an employee's activities following the end of their employment, the courts will want to see that the employer is doing this in the least restrictive way possible. That's why courts generally prefer non-solicit clauses over non-compete clauses, because they are less restrictive. In fact, if your employment contract includes a non-solicit clause that is as minimally restrictive as possible, and you held a very special role with your former employer, there is a good chance that your non-solicit clause might be enforceable. If that is the case, then it is generally a good idea to adhere to the terms of the non-solicit clause. The fourth thing you should know are the consequences of breaching the non-solicit clause. If you have a non-solicit clause in your employment contract and you breach that clause, your former employer can bring legal action against you. This legal action can involve a claim for damages, seeking to be compensated for whatever losses you caused through your improper solicitation, and even seeking an injunction restricting you from engaging in the specific activity. The fifth thing you should know about a non-solicit clause is that it can cause you headaches even if it's not enforceable. Even in this scenario where you have a non-solicit clause in your employment contract and it won't even hold up in court, that doesn't mean that your employer won't try to sue and enforce that clause. It may be that your employer brings legal action against you and that legal action drags on for years and years. And even though your employer might not be successful in getting an injunction or damages against you, you will have spent years in litigation spending money on legal fees through a very difficult process. For that reason, it's always worthwhile to consider compromises if you're subject to a non-solicit clause. For example, maybe there are specific clients that you're okay with not contacting for a set period of time. In a situation like this one, a reasonable compromise might be better than years of drawn-out litigation. Again, I'm Mike with Cashion Legal. We're an employment law firm based in Calgary, Alberta, and we help employees and employers with non-solicit clauses. Our goal for every one of our clients is to provide them with clarity, strategy, and peace of mind. If the content of this video is applicable to your situation, or if you need advice on another employment law issue, you can connect with our team through our website.